Hi, welcome to the video lecture for Chapter 7. This chapter focuses in on parties to crime and vicarious liability. So parties to a crime is based on this idea of complicity, which is the occasions where you can be held responsible for somebody else's conduct. And there are two types of complicity. There are accessories and accomplices. Accomplices participate before and during, while accessories participate after a crime was committed. Now, there is also important to distinguish complicity from vicarious liability, which is you are criminally liable for somebody else's conduct because of a relationship. So complicity deals with your level of participation in the crime, resulting in you holding a certain level of blameworthiness for the crime. Vicarious liability are the occasions where you will be responsible for somebody else. This often comes from a business relationship. So an employer might be liable for their employee's conduct. Other types of relationships fit here too, like fraternity. The institution of the fraternity versus the members of the fraternity can sometimes come into conflict, but that institution may hold some liability for the actions of the individual members. And this rests on a few different theories of liability. One is agency theory. This assumes that we're all kind of autonomous and that we can choose our own actions and therefore we're responsible. Forfeited, and so if we join in, we should be held responsible for joining in. Forfeited identity looks at when you choose to participate in a crime, you lose your ability to stand alone. You have forfeited your specific identity here. Common law had 4 parties to a crime. Principals in the first degree are the people who actually commit the crime. Principals in the second degree are persons who are present when the crime was committed and help commit it. This was more reserved for like a lookout or getaway driver. Accessories before the fact were not present when the crime was committed but helped prepare for it, providing a weapon that's later used for an assault or a homicide is an accessory before the fact. Accessories after the fact help somebody after the crime is committed, for example, harboring a fugitive. Under modern law, though, we have again simplified it to just accomplices and accessories. Accomplices participate either before or during, accessories participate after the fact. As far as the liability goes, if you are an accomplice, that liability attaches for that participation, and you are often punished as if you committed the crime itself. So you're prosecuted for the crime itself. Accessory liability is your liability attaches after the crime is over. And you're usually prosecuted for a minor offense that's separate from the crime itself. So you're prosecuted for obstruction of justice, for example, and usually with a much lower penalty than the actual crime itself. Accomplice liability consists of elements. We're coming back to our actus reus and our circumstances and things. Actus reus are aiding, abetting, inciting, or encouraging someone else to commit a crime, or being present at the scene of a crime when there's a legal duty to intervene. We have the mens rea of the intent to commit the actus reus, and then a minority that states the intent to commit the crime itself. For some specific crimes, we might have circumstances, and this is a conduct crime. The criminal conduct occurs at that point. Now, accomplices are not co-conspirators. A conspiracy is an agreement to commit another crime, and the Pinkerton rule established that the agreement to commit the crime and the crime itself are 2 different crimes. So accomplices are not co-conspirators. They could be, but that's not a foundational requirement. So when we're looking at the actus reus to be an accomplice, we are looking at that you had some positive act in aid of the commission of the offense. Some of the questions that come up are how much aid is enough. Some things that are almost always, that definitely are enough are driving the getaway car, being a lookout, sending the victim to the person who intends to commit the crime or harm them, preventing the victim from getting warnings about the criminal act, or providing supplies that will enable someone to commit the crime, so weapons or guns or drugs or whatever it is. Words can also accomplish if they encourage and approve the action, but just being at the crime scene is not enough. So mere presence is not enough to satisfy the actus reus. Now, your book has an example about, I guess the one exception though is if you flee. The flight can be, if you were just at the scene and you run away, that is some level of suspicion, so that can be considered, but it just being there and running away are not a crime in and of themselves. Your book has an example, Stevie Ullman. It was the mother of her son. She just moved in with her son and daughter-in-law. Her son kills the daughter-in-law and dismembers in the bathtub. He calls her up and asks her to lay on the couch and to keep an eye on the kids and not let them in the bathroom. She didn't participate other than that. And the issue is whether or not she is an accomplice, and the court finds that she's not. But definitely encourage you to delve into this case a little bit, Stewart versus Ulven, and to help kind of clarify what we're actually looking for an accomplice, beyond just participating before and during. Accomplice mens rea is usually purposeful or knowingly. You either need to intend to be an accomplice or intend to commit the underlying crime itself. So an example maybe of this type of mens rea is that you lease an apartment to someone you know is going to use that apartment for the sole purpose of prostitution. That can be enough to trigger this mens rea here. If you sell a gun to somebody you know is going to use it to shoot and kill someone, that is a mens rea that would satisfy this. Again, here's some examples of knowingly but not purposely helping somebody. So purposeful would be even more, remember, conscious object of the outcome. If you do it, if you are an accessory, you are most likely going to be prosecuted of a misdemeanor. To be an accessory, you need to have personally aided in the crime, knew a felony was committed, provided aid for the purpose of hindering prosecution. So you provided aid to help the person to escape, to not be prosecuted, but somebody else actually committed the crime. So again, our chart here, aiding a felon to avoid arrest, prosecution, or conviction, and you intended to help them for that reason. Your book has a really interesting case called State versus Chisholm that is super interesting, that really details out why this person was an accessory to a homicide. Vicarious liability, again, if we think back to the beginning of this video lecture, is where your liability is imposed for somebody else's actions. We transfer the actus reus and the mens rea to somebody else. The most common issue here is corporate liability, where we have this idea of let the master answer for the offense, and kind of is rooted in a criminologist, Edward Sutherland's scholarship. One reason why this happens is corporations are expected to self-regulate themselves, and if they don't, then they should be held responsible for the harm that occurs, for tendency to resist regulatory changes, implement those changes. If harm occurs, they should be responsible. And we have this legal fiction, let the master answer for the harm, which is that if your position puts you in a place of danger, or you're told by your boss to commit something that's a crime, that the corporate entity should be responsible. Your book also has an example of a fraternity. The fraternity itself was convicted of selling alcohol to someone under the age of 21, as well as prostitution, and the issue was, should the actions of the individual members be transferred to the entity of the fraternity itself? And the court does find that, yes, the corporation itself is responsible for these actions of underage alcohol and prostitution. As far as individual, though, sometimes parents are held responsible for their child's crimes, and you can also contribute to the delinquency of a minor. Parental responsibility statutes, like not letting your child operate heavy machinery or snowmobiles, or drive a car before they're 16 and licensed. Those are the thoughts that you are either your actions were not sufficient, or you omitted your actions based on your omission of keeping your child in line, and so sometimes you are responsible for that. These are the cases from this chapter. Again, I definitely encourage the State versus Ullman and the State versus Chisholm case as really great examples of accomplice and accessory examples under the current statutes. If you have any questions about any of the concepts we talked about this week, feel free to reach out during office hours or via email. I look forward to working with you.